embarrassed.
Everybody, we're going to get started on welcome back. Welcome to immigration. Immigration is a rather quiet issue in this administration. Not much to discuss. Actually, one of the issues, two of the issues in the workbook, we're going to skip over with apologies to anyone involved in them so that we have more time today to discuss the DACA cases, to discuss the cross-border case, and then we're going to devote the last part of this to emerging cases. There are a lot of those on asylum, on the border wall funding, and other issues, some of which, one or two of which, could get to the court later this term, and we want to devote some time to that. So, as a matter of fact, just last week, just this past week, there was a Supreme Court decision on one of those asylum cases, and there are two others ahead of it. So we're going to try to devote about half the time to DACA, get to the cross-border case, and finish up with some of these other issues. I have the privilege of having Erwin and the three Davids here. So when I say David, all three of them can respond. I don't think we need too many introductions here, but Erwin Chemerinsky, Dean of Berkeley Law, David Cole, Legal Director of the ACLU, David Savage, one of my many mentors at the Supreme Court, has covered the court for 33 years and just moderated the last panel. David Strauss, I think on loan to Harvard right now, but University of Chicago Law. And we're going to jump right into DACA so that we, as I said, can get to some of the other issues later on. Erwin, you want to get us started on DACA?
Sure. Let me start by saying how wonderful is part of the preview. It's so special to be here. I think one of the most important Supreme Court matters this term, by any measure, concerns DACA. It's three cases that are consolidated for oral argument. One is Department of Homeland Security versus University of California. The second is Trump versus NAACP. The third is McLennan versus Vidal. I think everybody's familiar with the underlying story. The Obama administration adopted a policy referred to as deferred action for childhood arrivals. It said for those who were brought to the United States under the age of 15, if they're in high school or if they have a GED, or they've graduated high school, if they've been honorably discharged in the military, and they're under age 30, they'll be given deferred deportation status, something that exists under immigration law. The Obama administration adopted the policy. The Trump administration then announced it was going to rescind the policy. I said at the very outset this is one of the most important matters before the court, and it's true by any measure. It's true in terms of importance at the human level. This is going to affect about 800,000 individuals and whether they're allowed to remain in the United States. I think it's important as we think about the Roberts Court. To what extent is the Roberts Court going to rubber stamp Trump administration policies, especially in the immigration area, or is it going to really stand up to the Trump administration in that area? This is certainly a case that could have important political ramifications. To tell a little bit of the facts of what happened here, really have to start with another Obama policy, and it was the DAPA policy, Deferred Action for Parents of Americans. And this was the Obama administration saying they would give deferred deportation status to those who were not citizens and not lawfully in the United States, but were parents of American citizens who were children. And again, it had to be individuals who didn't have felony convictions or serious misdemeanor convictions. A federal district court in Texas declared this unconstitutional and issued a nationwide preliminary injunction. The Fifth Circuit affirmed in a 2-to-1 decision, and it came to the Supreme Court in October term 2015. The court announced on the last day of that term that it was split 4-4, so it was affirming the Fifth Circuit by an evenly divided court. The state of Texas announced that it was going to bring a challenge to DACA based on the Fifth Circuit's decision and the Supreme Court's affirmation by an evenly divided court in the DAPA case. The Trump administration then announced it was going to rescind the DACA policy because of the determination that DAPA was illegal. And this becomes quite important. The justification that was given initially for rescission was the determination that DACA was likely illegal based on the DAPA decision. 3 different federal district courts ruled, one in California, one in D.C., one in the Eastern District of New York. The Ninth Circuit affirmed the district court decision in California. There were not decisions with regard to the D.C. case or the issue of New York on appeal. The Ninth Circuit says this should be regarded as a reviewable administrative agency decision, and the Ninth Circuit says that the justification that's given by the Trump administration is that DACA is illegal. It's not illegal. It was a valid exercise of the president's prosecutorial discretion. The Trump administration, to the Department of Homeland Security, then says, we have other reasons for this as well. And they give several other reasons. They say, this is of questionable legality, and we don't want a policy that's of questionable legality. They said, we really think that this is a matter for Congress. They said there was no valid reliance interest. And beside that, we believe that DACA was illegal, that President Obama didn't have the authority for it. The Ninth Circuit issues a supplemental opinion saying those are all post hoc rationalizations. None of those should matter here. The original justification that was given wasn't valid, so this violates the Administrative Procedures Act. Also, I should point out that the Ninth Circuit had earlier said that the complaint validly stated a claim for a violation of equal protection. In fact, in the Ninth Circuit, one of the judges, Judge Owens, in a concurring opinion specifically said, there's a claim here that the rescission of DACA is a denial of equal protection. Similarly, the district court judge in D.C., John Bates, who had issued a preliminary injunction, said that the new justifications offered don't really change anything, and that therefore the preliminary injunction stands. The Supreme Court granted review in all three cases, the Ninth Circuit case, the two district court cases. At this stage, the Trump administration brief and 7 amicus briefs on its side have been filed. The respondents' briefs have not yet been filed. The Trump administration filed 1 brief in the Supreme Court in all 3 cases. I can tell you that there are going to be 3 separate briefs filed in the 3 cases by the parties, though there'll only be 1 argument on behalf of the parties because they're consolidated for that purpose. And the cases are going to be argued on Tuesday, November 12th. There are 2 issues that the Supreme Court granted cert on. The first is, can there be judicial review of the decision by the Trump administration to wind down DACA? And it's interesting, they phrase it in their issues presented as winding down DACA. And the second issue that's presented was the winding down of DACA a violation of the law. As the former issue, the Trump administration says, this isn't reviewable under the Administrative Procedures Act. That the argument is that this is arbitrary and capricious in the Administrative Procedures Act, but under Section 701A2 of the Administrative Procedures Act, this is committed to agency discretion. Goes to a Supreme Court case, Cheney versus Heckler, that says that when there's matters that are committed to agency discretion, there can't be judicial review, and this should be regarded as committed to agency discretion. Now, as I said, we don't yet have respondents' briefs, but we do have the arguments that were made in the Court of Appeals. The Ninth Circuit rejected that argument, saying that the Trump administration is saying it's commanded by law to rescind DACA. That's a legal question. That's one that the court should be able to review, shouldn't be regarded as committed to agency discretion. In this case, could well turn on that first issue. Can there be judicial review at all, or is this a matter that's regarded as committed to agency discretion? Assuming the court believes that judicial review is possible under 701A2, then you get to the second question, is the winding down of DACA a violation of law? And the Trump administration says, we believe that DACA was illegal, but even if we don't say it's illegal, it was of questionable legality and we should be able to stay away from a violation of the law. They say this is really something that left to Congress in the political process, and they say there's no denial of equal protection. I think it's easy to imagine what the other side's briefs will say. I think they're going to rely a lot as to this issue on the Supreme Court's decision in Department of Commerce versus New York from June 27th. In Department of Commerce versus New York, which was much discussed last night, Chief Justice Roberts said that the administrative agency has to have a legitimate reason for its decision. It can't be a mere pretext. There, Chief Justice Roberts said that the Department of Commerce didn't have a legitimate reason for asking a question about citizenship on the census. Well, here, the reason that was given by the Trump administration initially was that DACA was illegal, and the respondents say DACA wasn't illegal. that it was an exercise of valid prosecutorial discretion by President Obama. It's estimated there are about 11 million undocumented individuals in the United States. The government at most deports about 400,000 a year. And so what the Obama administration said is, we're just choosing among the few people to be deported that we can relative to the numbers who are here, not to focus on those who were brought to the United States under age 15. And the defenders of this are going to say, under immigration law, there is what's called deferred deportation status. And they can point to examples from many presidents, Democrats and Republicans, who've granted deportation status. And they're going to say that all of the other justifications given by the Trump administration later are just post hoc rationalizations, that this was lawful, and that therefore President Trump's justification as stated is invalid. And they also are going to raise their equal protection argument that this is really based on race discrimination against Hispanics. Finally, offering thoughts about what's the Supreme Court likely to do. On the one hand, you couldn't have more sympathetic plaintiffs than these. These are 800,000 individuals who were brought to the United States as children. Many, if not most of them, have lived their entire lives in the United States. Where are you going to deport them to? You're going to deport them to places where they never grew up, where they have no contacts. And I should disclose here that I was co-counsel in one of several suits that were filed in California on behalf of these individuals. And I do think there's a strong argument that the justification that was given by the Trump administration that DACA is illegal is just wrong. DACA was legal. On the other hand, there's several reasons to be skeptical that the Supreme Court's going to accept that argument. We've got to remember that the Texas versus United States case was a 4-4 split, which indicates that at least Roberts, Alito, and Thomas believe that DAPA and DACA are illegal. Also, I have to say that I think there's a tension in the argument that's being made by respondents. The core of respondents' argument is that the president has great discretion when it comes to things like immigration. Well, Trump's argument is, I have discretion, and I can then rescind this policy. That seems to me to create some tension. Also, if you look at the position of the conservative justices with regard to immigration in the Trump administration, they've sided with the Trump administration. Think of Trump versus Hawaii, that was 5-4, or think of this summer, the order of the conservatives to lift a preliminary injunction against letting President Trump build the border wall, or what we're going to talk about from just this week, where a federal district court judge in San Francisco, John Tiger, had issued a preliminary injunction with regard to the asylum policy, and the Supreme Court stepped in, what appears to be 7-2, and stayed that order. It seems that the conservative justices and even sometimes the liberal justices are unwilling to stand up to the Trump administration here, which then would not bode well for the respondents. So that's at least the setup of the case.
That's an excellent setup, and I want to open this up to the panel, but one additional factor here, I think, is that, and it might be tempting for some of those in the middle of the court, if there is a middle on this case, perhaps it's Roberts, perhaps it's Kavanaugh, is that they could look to Congress to solve this. The president tweeted just last week, DACA will be going, this is his tweet, DACA will be going before the Supreme Court. It is a document that even President Obama didn't feel he had the legal right to sign. He signed it anyway, exclamation point. Rest assured that if the SC does what all say it must, based on the law, a bipartisan deal will be made to the benefit of all. So one question, and then we'll go to the panel, is whether anyone really thinks we're going to be deporting these folks, no matter who wins, or whether this is all a bargaining tactic on the part of the administration. So that and any other issues. Any of the Davids want to jump in?
A couple of thoughts. Just about the some of the positions that the administration took in this case. I guess three things. First, some of the things that my co-panelists said last night about the census case are even truer here. They said, you know, if the government had justified its position in a different way, it might have won the census case. I think that's probably true of the census case. I think that is clearly true here. I think if the administration had said, look, this is a discretionary decision, we're not saying that what President Obama did is unlawful. We're just saying it was his exercise of discretion. we choose to exercise our discretion in a different way, it'd be very difficult to explain why they can't do that. But instead, the very first justification was it was unlawful, it was unconstitutional, and then the subsequent things they said have the feel of post hoc rationalizations, whether they technically are in the administrative law sense or not, they have that feel a little bit. And now there's a sort of clear legal question. Well, was it unlawful for the Obama administration to do that? And that's a much more difficult question than can you exercise your discretion. So they've really put themselves in a difficult position. Second, it is really unusual for executive branch lawyers to disclaim power when there is any arguable basis for exercising that power. The reflex of most executive branch lawyers, certainly in the Solicitor General's office who are litigators, OLC is a little bit more judge-like, but certainly the executive branch in the SG's office who are litigators, the reflex is, you know, if we can make a plausible argument that the executive branch has the power to do this, we will make that argument. Now, we will say, look, we get to decide whether to exercise that power, but we want to make that decision. We don't want to hand it over to courts to make that decision on behalf of our administration and the executive branch as an institutional entity. And it's very odd, I think, for the government to take the position, as it did in this case, that no, we would not have had the power to issue DACA ourselves. That's really uncharacteristic. And I think, you know, that sort of thing is this kind of thing, depending on whether this sticks around, that can do long-term damage to the institutional interests of the executive branch. So that's I don't want to say it's surprising, because in some level it's not surprising, but in any other administration, a very surprising thing to see the government do. Third piece about this, also in terms of the interests of the executive branch, no one doubts that the executive branch, President Obama or any president, any executive branch, can exercise discretion about whom to deport. Erwin gave you the statistics. It is just inevitable. There'll be a lot of discretion exercised to allow deportable people to stay in the country, given the numbers 11 million versus 400,000. So there was no question about that. In the DAPA litigation, Texas said, oh, we're not challenging President Obama's decision not to deport these people. We're just challenging his decision to give them deferred action, this status that confers certain rights on you. But here's one of the things that's going on here. Before DAPA, I don't think this was true of DACA, but it was true of DAPA. Before DAPA, there were directives from the Secretary of Homeland Security, or actually a subordinate official in the Homeland Security Department, to the immigration enforcement authorities, what your priorities are to be in deporting people. And part of the problem was those weren't followed. That people in the field, because this is a massive and somewhat chaotic program of law enforcement, people in the field were not following those policies. They were picking people up and deporting them right away, even if they weren't, even if the executive branch's priorities dictated by the President and the Secretary of Homeland Security said these are not people who are high priorities for deportation. Part of the reason for conferring deferred action status on people is to make sure that won't happen to them, because now they actually have a card that says, you know, I have deferred action. You can't deport me. So part of what's going on with these programs is the executive branch asserting its ability to control what is going on in the executive branch, asserting its ability to control its own enforcement priorities. And that's why they give people deferred action status. When everybody agrees, they don't have to deport these people. And so it is really peculiar, from the point of view of the executive branch's institutional interests, really peculiar to see the executive branch saying, you know, we're not sure, in some cases we can't do these things that assert the power of the executive branch, and over something where you think it's really important that we keep control of this, because we need to set enforcement priorities, and we want to set them at the top, not have immigration officers in the field set them. So these are, I mean, I don't know if this will influence the decision of the Supreme Court, but they are really sort of odd, and even from the point of view of kind of the interests of the executive branch, really troubling developments in this case.
Well, just at the risk of playing the role of the skunk at the garden party, this seems to be I remember writing about after DACA, the notion was that this was a discretionary power of the president to say, and Obama said it in a very tentative way, that this was not even a formal rule, but as a matter of discretionary policy, we are not going to go after these young dreamers. They are the least culpable people. We're not going to seek to deport them. There was a lot of ruckus on the right about that, but I thought he had a reasonable argument to say this is within the discretionary power of the president to enforce the immigration law. And it sure seems to me that if the next president comes in and says, no, I don't want to do that, I don't want to maintain that policy, I think it was legally questionable, I'm going to not follow that, I'm going to, whatever it is, wind up. Even, I agree with all the points about the humane aspect of it, the political, but I would think that if the president had the discretionary authority to make this immigration policy, the next president has the discretionary authority to repeal it.
Question is, I'm sorry, David, just one quick thing. The question is whether they can rule on that basis if it's not the question presented and if the administration's argument is that it was illegal rather than he had the discretion and we
Why
had the
couldn't the court say that the administration thought this policy was illegal? They've now come up with several different rationales. I would assume the court would say they had multiple reasons of why they wanted to repeal it, and that's good enough.
So I think that David Savage's point is a reasonable point, but I think David Strauss's point that is not what the administration said. They didn't say President Obama properly exercised his broad discretion over this matter. We have similar broad discretion. We are going to properly exercise it in a different way. They took this position that I think was ideologically driven. If Obama did it, it must be illegal, and therefore we're going to, put that as reason A, with no other reason for why we are reversing it. And had they not done that, I think the challenges would have been much less effective. But having done that, they have made a discretionary power, turned a discretionary question, which may or may not be reviewable, but is not, even if it's reviewable, lots of authority to the executive, into a legal question where the court is at its strongest. The only other thing I would say is on the political ramifications that Erwin mentioned. I mean, this is a extraordinarily cruel effort to take away from 800,000 people who did nothing wrong of their own volition. These are children who were brought to this country innocently, and to say we're now going to send you home after you have developed your, you have become part of our community, not engaged in any wrongdoing. I mean, we have a number of DACA employees at the ACLU, people who went to Harvard undergraduate, who are devoting their life to public service, and to turn them around and throw them all out, it's just incredibly cruel. And I think in some ways it's a real challenge for the administration and for the Republican Party, because on the one hand, there's a sense that we have to reverse it because Obama did it. That's the ideological part. And then there's the second, we have to placate and play to the Trump base, which is sort of reflexively anti-immigrant. But on the other hand, nobody really wants to see 800,000 innocent people who are productive members of the society torn from their homes and sent home. And so, in some sense, the litigation has allowed the Trump administration not to actually have to confront that issue, but at some point it may have to.
May I ask you, do you think that's actually what would happen? In other words, do you think if the government wins this case that they actually will begin to seek to deport these people?
I mean, well, we saw what Trump said in his tweet. No, there will be a bipartisan agreement to figure out a way to keep them here. But Trump has said, very contradictory things on this subject. Maybe this is the only subject on which he said contradictory things, but he's said very contradictory things. I'm not going to revoke it. Then he did revoke it. So I'm going to give it to Congress. So I don't think it's possible to predict what will eventually happen to these individuals. But the notion that you're going to, put them at risk of deportation is.
Yeah, David, I think some will be deported. There's a case that I'm involved in Seattle, Washington, involving a man by the name of Garcia. The police were questioning his brother about something, and then they went to him and said, "Oh, what's your immigration status?" And he said, "I'm a DACA, here's all my registration." They said, "We're not following DACA," and they began deportation proceedings against him. There will be those instances, and what David just said is right. The DACA beneficiaries will live in great fear that they're going to be next because they will no longer have the protected deferred deportation status.
Yeah, just to reinforce that, I mean, a big part of the puzzle, big part of the situation is how both chaotic and sudden these enforcement actions are. So, you get a tip that there are undocumented people living in a house, you go there, and yes, some of them are undocumented and not DACA people, but then there's someone there who is a DACA person. The authorities will round them all up if there's no DACA and just put them all into deportation proceedings. And these proceedings happen quickly, and if people don't have a lawyer, there's not much they can do. And that's a big part of this. It's not that they will set up to round up all 800,000 DACA people specifically. That's not the way it'll work. But if they happen to come across a former DACA person who's deportable, they'll deport him, and that's the real danger.
And keep in mind, they have the information of who has DACA status, should they want to go after them, because these were individuals who were registered. And Rich, this may go to your question, and it goes to yours, David, as well. I never thought we would see a time when administration would separate parents from children, as it did at the border, in such a cruel way. I didn't think we would see an administration set up concentration camps, and it's the only way to call what exists at the border now in the way that they have. And so when you think of the cruelty of those policies, could I imagine them going after those with deferred deportation status? Yeah.
We'll try to save time for questions on this before we finish. So let's move to the cross-border case, and David Strauss is going to take us through that.
Yeah, let me do this relatively quickly. This is, I mean, it is in some sense an immigration case, but it's probably more a Bivens case than an immigration case. So the case called Hernandez against Meza, it's making its second trip to the Supreme Court. It comes out of some terrible facts, which are a Border Patrol officer shot across the U.S.-Mexican border and killed a kid who was, according to the allegations in the complaint, playing a game where he would run across the border up to a fence that was on the U.S. side of the border, touch the fence, and then run back to the Mexican side through a culvert that the borderline actually ran down the middle of the culvert. And the allegation was that the Border Patrol officer shot him across the border. So he was a Mexican national, the child, and he was in Mexico when he was shot, although the shot was fired by a U.S. Border Patrol officer from the U.S. side of the border. The parents of the child brought an action under Bivens seeking damages from the Border Patrol officer. Bivens, just to get everyone on the same page, Bivens is a 1971 decision of the Supreme Court that recognized, that allowed people to sue federal government employees for damages if the employee violates the plaintiff's constitutional rights. There is a statute, Section 1983, that allows a damages remedy against state and local employees who violate people's constitutional rights. There is no counterpart statute for federal employees who violate people's constitutional rights. Bivens established the equivalent remedy for violations of constitutional rights by federal employees. So they brought suit under Bivens. The Fifth Circuit said, well, we first have to figure out if there's a constitutional violation here. We think there's no Fourth Amendment violation because this is a Mexican national injured in Mexico. The other claim is there a Fifth Amendment violation because of a taking of his life without due process? The Fifth Circuit said, well, we don't know, but in any event, the official would be entitled to qualified immunity, which we don't need to get into for these purposes. Supreme Court then granted certiorari. This was in 2017 at the point where there's an eight-member court heard the case. Justice Gorsuch was not on the court when they heard it. And the court wrote a very narrow opinion saying, well, the Fourth Amendment issue, which the Fifth Circuit decided, that's very tricky, so we don't think that, we don't want to get into that if we can avoid it. They actually reversed on the qualified immunity question, but they said the antecedent question is whether a Bivens action is available here at all. And they remanded to the Fifth Circuit for the Fifth Circuit to decide whether Bivens action is available at all. Now, Bivens, as I said, was decided in '71. There were a couple of cases pretty soon after Bivens that also allowed Bivens remedies in different contexts. But since then, the court has very consistently refused to allow Bivens actions. Initially, it refused to allow it for fairly specific reasons, such as, well, there's an alternative remedy available. You don't need to seek damages from the official because you can get your relief from the government itself. But then over time, the court began to express increasing hostility to Bivens. And it eventually crescendoed in a case called Ziegler against Abbasi, if I'm pronouncing those correctly, an opinion by Justice Kennedy which basically just kind of kicked a lot of dirt on Bivens. And so Bivens belongs to an earlier era when the court was much more freewheeling in establishing remedies. We need to establish extending Bivens as a disfavored judicial action. It didn't overrule Bivens, but it sort of said we think Bivens should be confined. Well, actually said Bivens should be confined to the circumstances presented in that case. That case involved law enforcement officers, narcotics officers who kicked down the door of a house, arrested a person, handcuffed him, took him away without probable cause or a warrant. On remand, the Fifth Circuit said, well, the Supreme Court has told us to interpret Bivens very narrowly. There are lots of things about this case that make it look different from Bivens. Some of the reasons the Fifth Circuit said actually make some sense, such as this is a cross-border action. It involves action in another country. Congress has pretty consistently refused to allow foreign nationals to sue in these circumstances. Some of the things the Fifth Circuit said did not make a lot of sense, such as this will chill Border Patrol officials who have to make split-second decisions, but that's equally true in the context in which Bivens itself was decided. Anyway, qualified immunity is supposed to deal with those things. But the Fifth Circuit basically said, look, we got the message from the Supreme Court that Bivens is to be construed very narrowly. So we hold that a Bivens remedy was not available in this case. The Ninth Circuit, also dealing with a cross-border shooting that was egregious enough so that the government actually prosecuted the Border Patrol officer who did it, but the officer was acquitted. The Ninth Circuit held the opposite, held there was a Bivens remedy available. The court asked the Solicitor General for the government's views on both cases. The Solicitor General said, well, the Fifth Circuit had it right, there should be no Bivens remedy, but there's a conflict. Take the Fifth Circuit case, the Ninth Circuit case has some other complexities in it. Take the Fifth Circuit case, which is what the court did. I will be shocked if the court says anything other than Bivens is not available in this case. But as I said, this really is a case about Bivens and probably the latest chapter in the court's cutting back on Bivens. Itself kind of an interesting story, both interesting about what is going on and the way the court's thinking, and just interesting conceptually about should the courts have the power to create these implied remedies for which there's no statutory basis. Just to say one more word about that, Bivens involved an injunctive remedy. Justice Harlan, who wrote an important concurrence in Bivens, said, well, one reason to create a Bivens involved damages remedy. Justice Harlan said one reason to create a damages remedy is we have assumed for decades that the court can grant injunctive relief against federal officials who violate people's constitutional rights. Injunction, damages, both traditional remedies. In fact, historically, damages is a favored remedy. Why shouldn't we allow a damages remedy? The court has had no hesitation in allowing injunctive remedies. There's a recent opinion from Justice Scalia saying, oh yeah, injunctions, we can grant injunctions, long history of injunctions without statutory authorization, but damage is nothing doing. So there's a tension there, but I don't expect the court either to address that or to relent from its hostility to Bivens in this case.
So, David, I know you want to jump in. Let me just ask one thing.
Yes, go ahead.
Obviously, I think we know where Roberts, Alito, Thomas were on the first case. We have Gorsuch and Kavanaugh. Steve Vladeck, in his brief, mentions previous decisions by both of them. Is there any possibility for either one of those there? And David or anyone else, you can jump in.
I doubt it, but I mean, just because the impulse to say, look, this was from the era when the courts were much more aggressive in granting implied remedies, that impulse is so strong, but, you know, conceivably.
I was just going to say, the Bivens remedy is not a friendly phrase for a newspaper audience. So if the court says no Bivens remedy, what does that mean?
Means you can't get damages from a federal official who
And you think
violates your
they'll say
constitutional rights.
No suits involving cross-border, it'll be.
Oh, how
narrow.
broad it will be?
Yes.
You know, this is mostly guesswork, but I would guess they'll keep it pretty narrow. Why not? The cross-border aspect of it really is, I
So I
think,
can
a
write about
legitimate
that without even
concern.
using the phrase Bivens.
Well, if you say get money damages from a federal official who violates your constitutional rights, which is I think, maybe comprehensible phrase.
Okay, sounds good. All right.
Yeah. Oh, go ahead, David, please.
Oh, I should just say, we represent the individual in the Ninth Circuit case. You know, I think in some sense, the answer to how the court will rule was given by David's first comment, which is that Bivens is a case decided in 1971, the end of the Warren Court era. And Bivens, speaking of stare decisis, has not been overturned, but they've come remarkably close, and they've done it in an incremental, step-by-step fashion until, you know, what's left is you only have a Bivens action if your name is Bivens. And it's, you know, and it's not, and to me, it's not unlike the exclusionary rule, which they also have not overturned, but the court has incrementally cut back more and more to the point where it is the exception rather than the rule. I'm not optimistic. You know, I do think that in some sense it is a classic Bivens case. Bivens was about a Fourth Amendment, a violation of the Fourth Amendment in a search, and this is the violation of the Fourth Amendment in a seizure. Shooting someone without provocation violates the Fourth Amendment. Yes, it involves somebody across the border rather than somebody a few inches on this side of the border, but that may be a merits question, but it ought not be a question about remedy.
Prior to Bivens, if someone wanted to sue a federal officer for a constitutional violation for money damages, it would have to be brought as a tort suit in state court. That remedy is available to the extent that state law allows the tort suits to be brought, and that would be the way in which money damages would have to be sought. Now, what Justice Harlan, who David quotes, also said in Bivens, in his opinion, is for someone in the shoes of Wesley Bivens, it's money damages or nothing. In a situation like this, there is no injunctive relief to be had. And I think that Bivens was based on the premise, if there's a federal constitutional violation, there should be a federal remedy, and here a federal damages remedy. But I also agree, since literally 1980 in Carlson versus Green, there is no Supreme Court case that's held explicitly with Bivens that has ruled in favor of allowing the Bivens cause of action. The trend is what everybody on the panel has described.
We're going to switch. We got about 15 minutes, I think, maybe a little bit more. I'm going to go to David Savage to talk about the way in which some of these cases are coming to the court, the asylum case and the asylum cases and others vis-a-vis the SG's fast track strategy. And then we're going to go to David Cole, who has stepped into this panel and can talk about some of the specific cases. Among the 1,400 that he handles are some of the asylum cases and the leading border wall funding case. So, David?
Yeah, Adam talked about this a little bit on the panel last night. You know, the premise of this conference and a lot of other things in September, you talk about, here are the big cases that the Supreme Court's going to hear in the fall. They've been cases of they're going to review decisions of lower courts, hear arguments, and issue an opinion months from now. And were we sitting here and I were able to say, well, the Supreme Court this fall is going to decide a big case about border wall funding. It's really a great constitutional clash in a sense that the president wants $8 billion for a border wall. The House Democrats say no way. The Congress sort of shuts down. They end up with some agreement that funds the government, but no border wall funding. A day or two later, the president says, I'm going to invoke my executive emergency authority and appropriate money from other parts of the budget, the Pentagon's budget. The ACLU and others, the Sierra Club sues. A judge blocks it in Oakland. The Ninth Circuit blocks it. And in mid-July, the Solicitor General files an emergency appeal. On a Friday evening in late July, the court issues a essentially one-paragraph order with no reasons, really, for a 5-4 ruling that says, yes, we're going to lift those orders. The president can go ahead and spend the $2.5 billion. So a very, all the lawyers in the room would correctly say, well, that's not a final ruling. They didn't actually decide. But I would say for the most of the president's first current term in office through 2021, he's pretty much free to move the money around and spend the money even though Congress said don't spend the money on that. This is an interesting development. Now, on the asylum issue, this has been the heart of the fight along the southern border. All these people from Central America and now apparently Africa coming, and President Trump has said the asylum law is sort of a mess, and I don't want to use that word entirely, but I think he's got a point that the asylum law is a little bit strange. It's got an open door premise. It says any alien who is physically present in the United States or who arrives in the U.S., whether or not at a designated port of arrival, may apply for asylum. Early on, the administration tried to say, if you don't arrive at the port of arrival, you can't seek asylum. And the court late last year on a 5-4 vote allowed that to be blocked. 4 of the justices would have lifted that, even though the law seems to say it doesn't matter whether you're at a dead. But the second part of it is, once you get in to apply for asylum, it says you have to have a well-founded fear of persecution on account of race, religion, nationality, political opinion, or membership in a political social group. And my sense is that, I haven't looked at all these cases. These people are not fleeing political persecution. They're not members of a political or a particular social group. I can imagine, if they're gays and lesbians or something like that, they're being singled out because they're fleeing gang violence in their communities. Nonetheless, under the system we have, that they now have something like 400,000 pending immigration cases. So it doesn't seem like a great system. I was struck by the comment early on about the president said on DACA, if the court lifts this, we'll go back to Congress and work out some deal. It seems to me asylum is one of those areas where the administration should have gone to Congress in 2017 or 2018 and tried to make some modification in the asylum rules. But nonetheless, in mid-July of this year, they announced some new, quote, interim final rule that says if you arrive at the southern border and you have traversed, if you're fleeing from Central America and you didn't apply for asylum in the first safe country, which is Mexico, and you weren't turned down, you are ineligible. Federal judge blocked that. The Ninth Circuit blocked it, limited to the Ninth Circuit. But, a couple days ago, the Supreme Court, another one-paragraph order, no reasoning, lifted those orders and allowed the administration policy. So this is a major change in asylum law, and as I say, a major change on the whole issue of border wall funding, both of them in, orders with no reasoning. It strikes me as not a good way to run the legal system. It seems to be, it'd be good to have Congress decide some of these issues, and it's not good to have them decided on this sort of fast-track run through the system where you make a big decision with all the justices are, around the country giving speeches or selling books or whatever, and in between they, issue this pretty big order. So that's my rant on that subject.
So David Cole, several of these are headed to the court. One is, you want to talk about the one that I can't pronounce that is likely to be granted soon, and then the 2 East Bay cases, and on border the Sierra Club case. That's a lot.
That is a lot. Just to put the, let me do it in a slightly different order, just to put the asylum ban cases in context. I think what we have seen for the last several years is the Trump administration taking every action it can to deter people from applying for asylum. It began with family separation, what Erwin mentioned. That family separation was explicitly about maybe if we take babies from their parents, it will deter people from coming to this country and applying for asylum. That was literally the justification for separating families. The courts enjoined that. They then took they adopted a practice of de facto imprisoning you if you applied for asylum. So when you apply for asylum, you have a credible fear interview, and if you're found to have a credible fear, then you get to go before an immigration judge and you get your case heard, but because we don't have enough immigration judges, that often takes a year. And the Trump administration was simply locking people up and denying them any ability to be free while that determination was pending, whether or not they posed any risk of flight or whether or not they posed any danger to the community. We challenged that, enjoined by the courts. They then adopted a de jure. We're not going to give bond hearings to anyone who applies for asylum, so that it's not just de facto, but de jure. We challenged that. The courts enjoined it. They then adopted the policy, the first one that went to the Supreme Court, where they said, even though the statute says anyone who fears persecution at home can apply for asylum, whether they came to this country lawfully or not, the Trump administration took a position that if they came to this country unlawfully, they can't have asylum. Directly contrary to the statute, the courts enjoined it. That's the one that the Supreme Court denied the government's request for a stay. The most recent asylum ban is another crack at this, and that is to say, if you come through a third country and you haven't applied for and been denied asylum in that third country, we're not going to give you asylum. That is a clever way to effectively deny asylum to everybody from Central America other than Mexicans, because they have to come through Mexico, despite the fact that the statute specifies only two circumstances in which coming through a third country deprives you of the right to seek asylum, and that is where you have been firmly resettled in that third country, granted authority to stay in that third country, and then you come to the United States, but that's not what's going on here, or where we have an explicit safe third country agreement with a third country, and that's not applicable here either, so the Trump administration just overrode that as well. And then, of course, we have the border wall, where, again, the courts enjoined it because Congress said you can't have this money. Trump did everything he could to get them to say yes. They ultimately said no, and then he spent the money anyway. Again, the courts enjoined it, and the Supreme Court granted a stay. So it is a full frontal assault on asylees. There's still another one where they changed the standard for getting asylum. The Attorney General, Sessions, changed the standard, made it harder to get asylum. That, too, the courts have enjoined. That has not gone up to the Supreme Court. So there is a full frontal assault. And I think what this illustrates is that if the executive has tremendous power over immigration, and if it wants to make it really, really difficult for people to apply for asylum, it can do that. And it's extraordinarily difficult for the other branches to even keep up with what the administration is doing. The case that, and some of those cases may well go to the court this term, probably the most likely is the border wall case, because it's scheduled for argument in the Ninth Circuit on an expedited basis in early November, and so I expect we'll get a decision by, maybe by the end of the year, and that case may then go to the court depending on how the Ninth Circuit rules. The other case that I was asked to talk about is a case called DHS versus Tharasigiyam. I think that's the correct pronunciation of his name. He's a Sri Lankan individual who was subject to something called expedited removal, which is a statute that allows for the removal of certain foreign nationals, those who have recently entered and entered unlawfully. They are subject to a procedure that allows for a very summary administrative procedure, and then essentially no judicial review. The only judicial review that is available is if you claim, I'm not Mr. Tharasagiam, and I can't even pronounce his name, so I can't be him. A mistaken identity claim is the only claim that is subject to judicial review. And so we have litigated this issue in two circuits, in the Third Circuit and in the Ninth Circuit, and they've gone opposite ways. The Third Circuit said, that's fine. The claim that we make is that under the habeas corpus provision of the Constitution, judicial review of people who are detained, and in order to deport somebody, you need to detain them, so habeas applies to the immigration, the action to deport somebody. There is a right to judicial review of a claim that you were unlawfully detained and therefore being unlawfully deported, and there are many ways, many reasons why you might be unlawfully detained and unlawfully deported other than mistaken identity. Like that the procedures that were applied to you were inadequate, or that the immigration judge incorrectly interpreted the immigration statute. Under the expedited removal statute, those claims are not reviewable. Our argument is that under the suspension clause of the Constitution, those claims must be reviewable unless Congress expressly suspends the writ of habeas corpus, which it has not done. The Third Circuit ruled against us on that. The Ninth Circuit ruled in favor of us on that issue, and the United States has sought review on the basis of that circuit split. And it will apply to a lot of people, because the Trump administration has recently expanded the scope of expedited removal so that it recently applied only to people who were here who were caught within 100 miles of the border and had only been here for 2 weeks. The Trump administration recently expanded it so it applies to people who are detained anywhere in the United States and who have been here less than 2 years. So it's a huge expansion of this process that provides for effectively no judicial review, and the question is that consistent with the suspension clause?
We're almost out of time. David, go ahead.
Well, I was going to say, suppose you win that, does it mean every person who crosses the border and they want to remove that person in an expedite has a right to a federal court review of his or her situation, or only a small group of people?
It means every person, and the predicate for that would be, that is where they have a statutory or constitutional challenge to their removal. And the predicate for that is the suspension clause applies, like all other provisions of the Constitution, at a minimum to all persons within the United States. And the court has, has said repeatedly that constitutional provisions apply to all persons within the United States, regardless of whether you're here lawfully or unlawfully. So yeah, and then the question is, what does the suspension clause require? That is a question which we litigated some years ago in a case called INS versus St. Cyr, where Congress also sought to restrict the scope of judicial review, and the court in St. Cyr interpreted the statute to preserve statutory and constitutional challenges to your deportation. So if it's purely a factual issue, no, but if it's a legal or constitutional issue, yeah, you have a right to judicial review. But that's been the case for a very long time. This expedited removal provision is relatively recent and has been, until the Trump administration recently expanded it, has been very limited in its application, so it hasn't applied to very many people.
David, one quick question for you, and that is what for David Cole, I'm sorry, and that is the different rulings that the Supreme Court issued on, I guess I'll call them East Bay 1 and East Bay 2. What's the rationale for going one way? And I guess we're talking about the Chief Justice going one way on illegal entry, going the other way on third country, and does it portend anything for merits if either of those get to merits at the Supreme Court?
Yeah. Well, they probably, the answer to the latter part of that question is yes, likely portend something on the merits, although, I agree with David, it's sort of unfortunate that that's how these cases are getting resolved these days. I can't read, only Joan Biskupic can read Chief Justice Roberts' mind, so I don't know how he drew that distinction, but I think what the government would argue is that the first case where the Trump administration said you can't apply for asylum if you didn't come into the country at a port of entry legally is directly contrary to the statute, because the statute says you can apply for asylum whether you came into the country legally or illegally. I am paraphrasing, but that's essentially what it said. In the second case about transiting through third countries, we're making an argument that's essentially a sort of implication. That is, Congress did not say expressly, you can apply for asylum even if you've transited through a third country. And then the Trump administration comes and says, no, you can't. That's what they did on the first one. On this one, they said, you can apply for asylum if you face a risk of persecution. And then in two other parts of the statute, they say you can't apply for asylum if you face a risk of persecution if you've been firmly resettled, or if there's one of these formal bilateral safe third party country agreements with respect to the country through which you came. And so we say that implicitly that precludes the administration from putting forth yet another bar based on transiting through a third country, because Congress addressed the issue of transiting through a third country and said there are only two circumstances, neither of which apply to the Central Americans, that would bar. So I think that's probably the difference.
We're past time already. If anyone has a pressing question on DACA or anything else, I'll take maybe one question. Yes, there is a pressing question.
I was maybe less a question than a comment on DACA. Just to put the legal discussion in a broader context, I think there's a real political accountability question in this case. The president wants to be able to say, it's not my fault I'm terminating DACA. It's just illegal. I wish I could do something to the Dreamers, but I can't. And that's both political accountability, and it's also a way to force Congress to act, right? By saying, it's illegal. The only way you can protect the Dreamers is if you make a deal with them, even though you rejected a whole bunch of deals previously. And then in response to David Savage's comment about deportation, deportation is part of it. Work authorization is much more important. These people, as a result of having deferred action because of longstanding policies of the executive branch, they have work authorization. They get to actually participate in society. If DACA is eliminated, even if you're not deported, you're going to lose your job. You're going to use your ability to go to a hospital because you might be deported, and your life is sort of destroyed.
Good point.
I know we have people in overflow. Let me just tell you that that was Andy Pincus, and it wasn't a question; it was a comment. So I'm not gonna even try to repeat that. Anyone else? Quick. Yes, Allie.
I was curious about your thoughts on the first question presented in the DACA case about availability of judicial review. It seems like an attractive off-ramp for the Chief Justice, but can it be squared with the census case? What do you think will happen?
It's a great question. What the Trump administration is saying is that under 701A2, if it's about arbitrary, capricious review, it's committed to agency discretion and there shouldn't be judicial review. But what the Ninth Circuit there said is when it's a question of law, and the Trump administration is relying on a question of law, it's ultimately for the courts to decide question of law. In fact, Judge Wardlaw's opinion in the Ninth Circuit quotes the language of Marbury versus Madison, that it's the province and duty of the Judicial Department to say what the law is. And there is such a parallel to the census case, because in the census case, what four conservative just said is, we just shouldn't be reviewing this at all. And yet the majority said, yes, we've got to make sure that there is a legitimate justification and that there's been a rational stated ground given. And that's exactly what the respondents are arguing here, that the justification given isn't a legitimate one, and they've got to go back and come up with a legitimate justification.
Can I just add one thing to that? You know, we know that at least 4 of them thought that DAPA was reviewable because they would have struck it down. And we can guess which 4 they were. The government in its brief actually has a line trying to explain why DAPA was reviewable and DACA is not, but it's pretty thin distinction. So I wonder if 4 of them, if they'll be stuck. I mean, I'm sure that, you know, those are 4 conservatives. And I wonder if they'll feel, look, we've already said this is internally, we haven't written it, but we said internally it's reviewable, and we'll feel stuck.
We are eating into the time for Just Braven's business panel. Jess, do you have a question? We're going to call it we're going to put a 30 at the end of this. We'll probably take, what, 5 minutes and come right, 10 minutes, Neil says, and come right back. I want to thank the 3 Davids and Erwin for the panel.